Everyone, will give everyone a few minutes to assemble and then we'll get started. Thank you. Well, welcome everyone. I'm Andrew Hurd, the Executive Director of ACEC-Ontario. And on behalf of my colleague Dan Causey, Executive Director of the MEA, and myself, I'm pleased to welcome so many of you to today's discussion on the updated MEA ACEC-Ontario Standard Agreement for Engineering Services. The updated standard agreement was developed through collaboration among municipal engineers, consulting engineers, legal and insurance professionals. It reflects the industry's best practices and a shared commitment to engineering excellence. Today, we are delighted to have with us a panel of experts to share their perspectives on this agreement. So let's meet our panel. Matt Eads is the Vice President and General Manager at Associated Engineering. He's also a member of the ACEC-Ontario Board of Directors. Matt has over 30 years of consulting, engineering, and project management experience in a wide range of sectors, including municipal infrastructure, water, wastewater, institutional, buildings, and transit. And Nick Forstall is the head of Macmillan's National Infrastructure and Construction Group. A practicing engineer before becoming a lawyer, Nick's practice is dedicated to the construction, infrastructure, and development industries. Matthew Miedema is the Director of Engineering at the City of Thunder Bay and the immediate past president of the MEA. He oversees the delivery of engineering and construction services for the city's infrastructure and facilities assets, ensuring they meet high-quality standards and sustainability. And Sabina Taylor is Vice President at Hewwood Canada. Sabina specializes in the professional liability market, providing services to multinational engineering companies in Ontario. Now, before we begin, let's take a moment to acknowledge these lands we conduct business on. ACEC-Ontario and MEA recognize that our work and the work of those here today takes place on the traditional territories of a broad range of Indigenous peoples across the province. We recognize and deeply appreciate their historic connection to this land. We also recognize the contributions that Métis, Inuit, and other Indigenous peoples have made in shaping and strengthening this province and our country as a whole. We acknowledge that there are 46 treaties and other agreements that cover the territories now comprising Ontario. We are thankful to be able to work and to live in these territories, and we pay our respects to Indigenous elders past, present, and emerging. So please note that this webinar is being recorded and will be shared later on ACEC Ontario's website and MEA's website as well. The panel will be taking questions. If you have a question, please enter it in the feature. They will be monitoring questions as they come in and will address them to the panel at the appropriate. We'll get questions as we can. For additional questions, we'll have our website and communications links at the end of this presentation. Please reach out to us using those modes of communication and we will respond to you. And on that note, over to Matthew and Matt for an industry perspective.
Thank you, Andrew, for the wonderful introduction, and welcome to everybody this afternoon on a winter day, at least in Thunder Bay, at least. So I'm representing the MEA, Municipal Engineer Association, and we'll kind of highlight a few things of our collaborative approach with ACEC-Ontario on this updated agreement. So next slide, Rish. So I'm excited today to open this discussion and presentation on the updated MEA ACEC-Ontario Standard Agreement for Engineering Services. As Andrew mentioned in the opening, this updated agreement is really a highlight of a culmination and extensive collaboration between both municipal engineers and consulting engineers. Just to remind everybody, this agreement is intended for use by municipalities in Ontario employing professional consultants for performance of engineering services. The agreement is in PDF format and there are fillable fields throughout the document. And we also note there is an accompanying user guide that provides further information on the agreement and how to use it. So just to highlight again, the MEA ACEC-Ontario agreement is a long, valuable resource for municipalities and consulting engineers to use. It's been in use around for some time, and this latest update highlights an extensive collaboration, making sure it is a well-balanced agreement that favors trust between both consulting engineers and municipal engineers, and is a comprehensive agreement that clearly defines roles and responsibilities for all. Using this agreement can help you streamline your procurement practices, knowing that other municipalities support it and consulting engineers support it as well. It is a fair agreement that establishes risk between both parties. So MEA is very supportive of this agreement, and we look forward to using it in years to come. And we support all municipalities to kind of go ahead and adopt this agreement in your practices. I'll turn over to Matt Eads to kind of speak on behalf of ACEC.
Yeah. Thanks, Matthew. Yeah. Just reiterate how proud I am to be part of this group and part of this ultimately preparing this document and the supporting guidance document. Taken a long time, a lot of effort, a lot of good discussion, and as Matt said, it's a very useful document. We'll obviously track the developments within the industry as things kind of evolve, and we're obviously providing regular updates on things as the industry does evolve. Again, the team's efforts will continue. So part of this session is to answer some questions, but obviously if there is any feedback associated with the agreement and the guidance document, please don't hesitate to reach out to both entities. And as I say, being proud to be part of this and the industry collaboration to get this document out for use in the industry. Thank you.
Okay, so I will be running through some of the highlights of the features of this document, including what have been some pretty significant changes made from the older version of the document through the collaboration that Matthew and Matt were just describing. A fair bit of content to get through, so going to be taking a pretty high level summary of these key terms, but as Andrew mentioned, we do have the Q&A box up, and we'll be happy to answer questions that the participants might have. So jumping right in, one of the things you may notice about the agreement is, first of all, there is a much larger definition section. And maybe to take a step back, the agreement is separated into a few parts. We have the cover page recitals of the agreement where you fill in the party names. We have the definitions section, Article 1 with the general conditions, Article 2 where the services details get filled in, and Article 3 where details about the fees and disbursements get filled in. And so as mentioned, the definition section is much longer this time, and that's because we've tried to simplify the content and the ability to read the actual terms with key, terms with a lot of adjectives and other things being put into the definitions. Definition of standard of care, for example, is one that we've added and provides a helpful reference as this definition is tied to and consistent with the engineer standard of care at law. The agreement also provides opportunity in a new section 1.1 for the parties to fill out all of the documents that will be comprising the entirety of the contract, the full agreement. And it allows, while it proposes a certain order of priority as between those documents, it allows the parties to edit that. So it suggests, for example, that if you have supplementary conditions, that would be the top priority document, since it would modify the general conditions and other articles of the agreement. But again, the parties could move things around, move an article up to a higher order of priority depending on what is needed for their deal. And we also note that in a new section 1.6.3, we've made clear that the engineer can rely on the accuracy and completeness of the information in the documents it's provided, including all of the contract documents. It does provide that the engineer represents that they have reviewed the documents and not identified any errors or omissions. And if they do identify any errors or omissions in the document, imposes an obligation on the engineer to bring that to the client's attention. Next slide, please. So as I mentioned, Article 2 is where the agreement contemplates the details of your project-specific details of the services to be provided to be filled in. And so there are editable fields in Article 2 for this purpose. And it includes a prompt for not only what's included in the services, but also to be clear about what is excluded from the services, recognizing that that a common dispute that can arise between parties is what is in scope, what is out of scope. And so these fields encourage users of the document to turn their minds to this at the outset. What are we offering as our services from the engineer, but also what are the things that we're not including at this time? That ties directly into the terms that relate to additional services. So additional services is one of the terms that we've defined, and it is services that are not contemplated at the outset of the agreement, that are not included in the services detailed in Article 2. And the changes section in section 1.3 sets out the process for how the parties will communicate with each other if either party believes that a circumstance or a need for a change to the services has arisen. Um, and so that again requires, for example, the engineer to communicate, I think a request that's been made of me contemplates an additional service. It also allows the client to take the position that this is not an additional service, but I nevertheless require you, provide written direction for you, engineer, to proceed with those services. And any dispute can then be resolved in accordance with the dispute resolution process. Again, through the consultation process of the parties, we also wanted to acknowledge and have a term in section 1.3.4 that specifically talks about where emergency services may be required, where the engineer, in compliance with its professional obligations, determines that something needs to be done on an urgent basis, such that the process with timing for communication, response about the need for the services, where that is just not practically possible due to the urgent nature of what's required. Section 134 speaks to how that can be handled by the parties and empowers the engineer to fulfill their professional obligations. Another concept that is newer here as well is with respect to client obligations. So we do have section 1.4, which sets out very standard obligations of a client, like responding to requests for information, generally making clear that it would be the client that is obligated to obtain the necessary approvals, permits, licenses for the project. But there is space provided in Article 2 following the sections where we set out what's included or not included in the engineer's services, but where you may add or detail further additional client obligations if that's appropriate for your project. Engineers' compensation is another one where we have provided a full article, a separate article to really get into the options and choices and terms for payment. And so, first of all, there are 4 different options for payment provided, and they actually have check boxes in Article 3 that you can select depending on the commercial agreement that the client and engineer have reached. So the first option is performing the services on the basis of percentage of the cost of the work. Cost of the work is one of those defined terms that has been added. And those payment terms also provide for a process of how the engineer gets paid while the final determination of cost of the work won't occur until completion of the work. It details how and when cost of the work will be estimated for the purposes of compensating the engineer as the project progresses, and then what happens, for example, if um, completion of the work is delayed for a protracted period of time, which period of time is one that the parties can actually fill in Article 3. With respect to time basis, it allows for that is, the obvious. The engineer will perform the services on the basis of hourly rates. The terms there provide for adjustment to those rates if the term of the project is greater than 1 year. Also provides that the client can request estimates. So again, trying to keep this fair and balanced. The client can request an estimate for services to be provided, and the engineer is pursuant to the terms of that time basis compensation in Article 3, not able to exceed the estimate provided unless they get further written direction from the client. So again, allows some communication, provides expressly for that in looking to balance those interests between the parties. Upset cost limit basis is effectively performing the services on the time basis, but to a stipulated upset cost that the parties can fill in the document, which is distinct and different from an estimate. The estimate is not as firm in terms of the contract provisions as the upset cost limit. And the last option is the traditional lump sum basis. And to be clear, the agreement also provides in Article 3 for the engineer to be reimbursed for expenses like disbursements, these types of costs that they incur in performance of the services for all of these payment options except for lump sum. So when the compensation is being provided or on the lump sum basis, it is assumed by default in this document that all of those costs are included in that lump sum, but otherwise those expenses are provided to be reimbursed in addition to the percentage of cost or the time basis compensation for those fees. Finally, well, not finally, actually, there's 2 more points here. Invoicing. So first of all, we've provided payment terms that are consistent with the Construction Act's payment obligations in terms of 28 days from receipt of an invoice, but also codifying the requirement to provide notice of non-payment within 14 days, again, consistent with the Construction Act's prompt payment. Further recognizing that the Act stipulates requirements for proper invoices, but that owners, clients often also want to add, for example, statutory declarations, things like this to the requirements for a proper invoice. Article 3 provides space for that. So it lists the default obligations or requirements for a proper invoice and then provides a space for the parties to fill in more. And finally, there is an audit section provided in section 1.9, which allows the client to audit the fees, compensation that the documents, records that the engineer has, with the exclusion of, again, lump sum. So it's an audit on the basis of time and materials. So if you are performing the services on the basis of a lump sum, that those costs would not be subject to those audit rights. Next slide, please.
Nick, we have some questions here. First one is there a prescribed form for when changes are approved such that they tie to the contract terms?
No, there is not a prescribed form, and we don't use the terms change directive or change order, for example. So the requirements for a change to be effective is writing. It needs to be a written communication, but the contract is not more prescriptive than that in terms of the form of that written direction or agreement between the parties about any additional services. With respect to can the options be combined, I see that there. There's no reason that it can't be, although I would say that you would probably want to use either supplementary conditions or other spaces that have been provided in the agreement for added terms to clarify which services are subject to which payment option, because the agreement doesn't necessarily automatically stipulate, okay, well, this part of the services will be subject to a lump sum fee versus that part of the services will be performed on a time basis. But it does not cross out, for example, if you click off lump sum, the other options remain available and you can click off all four in the form, for example. But as I said, I think you'd want to then add or supplement terms to make clear about which payment terms apply to which services being performed. Next slide, please. So time for performance. In section 1.10, we deal with time for performance being stipulating in section 1.10.1, we set out when the services are to commence and when the services are to be completed. And that is at the later of a date that the parties can fill in. So January 1st, 2026, for example, or a specified duration. So you might say that the services will be completed at the later of January 1st, 2026, or 24 months after the work has been completed. So there is that, and that is then becomes defined as the schedule for the engineer's performance. Again, there's opportunity for the parties to agree in writing separately to additional milestones or timing, but the contract form itself by default contemplates just those two dates as comprising the engineer's schedule. And I will note as well that in the definition of change in the earlier section, extension to the services is included as what could constitute a change. And so so there is potential there for if the duration during which the engineer is to provide services is extended beyond what was originally agreed, that could constitute a change. Further in this section, there is a provision that provides that if the start of the project is delayed for more than 60 calendar days, so the work doesn't get started for at least 60 days, that then the engineer is entitled to renegotiate the terms of the agreement, understanding and recognizing that pricing, compensation, etc., that may have been locked in at that time could have changed during that delayed period. And finally, we have a new definition of force majeure, which, while it does include a list of items, fire, acts of God, things like that, that we agree would constitute a force majeure, it really is now focused on criteria that need to be met for the event or circumstance to qualify as a force majeure event for the purposes of the contract, that being the events outside the party's reasonable control. They could not have reasonably prevented it, and it wasn't caused by that party's negligence or impecuniosity. And then where you have an event of force majeure, neither party is liable for delays caused by that. Next slide, please. Another item that we've elaborated on in this version of the contract and that was subject to a lot of discussion is the terms relating to deliverables, intellectual property, and the licensing associated with that. So some key definitions that have been added to this agreement are deliverables, which defines the materials, the plans, drawings, reports, etc., that the engineer will be producing in the course of performing the services for the project. But further, we've added a definition of engineer's IP. So that being the intellectual property, the know-how that the engineer brings to the table. And the default in the agreement is that the client is granted a license for use of those deliverables. Now, that license is broad in the sense that it allows use of those deliverables for construction, use, occupancy, maintenance, repair, renovation, alteration, additions. So it gives the client what they need to be able to use those deliverables to get the project completed, and for use of the project long after the agreement ends. It does not, however, give the client ownership of those deliverables. Um, there are also, you might have seen, there are additional licensing options provided for in the contract. The default is that these do not apply. So when you look at the form, in the default, they are struck out, but you can click a button that says applies, and it will then remove that strike and provide these additional licensing options, which, for example, if selected by the parties because they've agreed to this broader license, would allow the client to use those deliverables for other works or other projects other than the one that is the subject of the contract. But the real hallmark here, and what's absolutely critical, is that in all instances, that engineer's IP is protected so that it always remains owned by the engineer. That's your bread and butter. And so we want to make sure that the terms here are very clearly protecting that. But further, made very clear that if those deliverables, whether pursuant to a license granted here or otherwise, if they're used without the engineer for another work, another project, that the engineer is not liable for any of those amendments. So again, balancing the interests of the client and the engineer and making sure the client gets all the rights that they need for the product, the deliverables that they are paying for their project, but also making sure that the engineer's IP and that their liability for use of those outside of their intended purpose or without the engineer being involved, that they are not liable for that. Next slide, please. So indemnification and limitation of liability. Again, the approach here is intended to be very balanced. So all of the indemnities are mutual, flowing both from the client and the engineer to the other party. And the indemnities provided are tied to negligence and breach of contract. So they are tied to fault, as opposed to being broadly connected to, anything and anything that might relate to this contract or the services or things like that that we sometimes see in agreements. The engineer's indemnity has also been revised to provide for reimbursement of the client for their legal fees, including defense costs, once liability has been determined. Now, you might ask, why is this? And this is because, as Sabina, I'm sure, could speak to as well, that where you have an obligation to defend, which we often see in indemnity clauses, that can require the engineer to be liable to the client for these defense costs before the fact of their fault has been determined. So it could be that they find themselves paying legal fees, defense costs, and then ultimately it's found that they were not liable. And in those circumstances, often those types of costs are not covered by the engineer's insurance. And so to make sure that the client will have their defense costs covered in the event that those costs were incurred because of something where the engineer was at fault, that is being provided for, but it's being done after the fact, after that dispute has worked its way either to settlement or to resolution, so that liability of the engineer doesn't arise until after it's been determined that they are responsible for that. Another one of the definitions that we have is consequential damages. And so this is defined not only to define or include the traditional consequential damages, punitive, exemplary types of losses, indirect damages, but it also is defined expressly to include things like lost profits and other things that sometimes might not be an indirect loss. And the agreement provides for a mutual exclusion of both parties' liability to each other for those types of losses. So neither of them are liable to the other for consequential damages. We also have an overall limitation to both parties' liability. This is broken up into certain parts, in particular where the claim is covered by insurance required to be carried by either party, it is tied to or capped at the amount of that insurance. Where the liability or claim is not covered by insurance that one of the parties is required to carry under the agreement, then it is capped at the compensation paid to the engineer, the total amount of the compensation paid to the engineer under the agreement. And there is no cap or an exclusion of that limitation to liability for third-party claims for bodily injury, property damage, which is a traditional and normal course exclusion from a liability cap of this nature. Finally, we have, again, a mutual provision providing that shareholders, officers, directors, employees in their individual capacities of both the client and the engineer do not have liability under this contract. So liability would rest with the parties, the firms, the entities of the contract. Although, of course, if it were an individual and as an engineer, for example, entering into the contract, this wouldn't apply to them. But but in the context of a larger firm entering into the agreement, it would mean that the individual engineers would not have personal liability. With respect to suspension and termination, we've have broader or expanded terms dealing with this. So in section 1.11, we have the ability of the client to suspend the services effectively for any reason in 1.11.1. So a lot of discretion given to the client there and their ability to suspend the services. But then to balance those interests again, if that suspension was not due to the negligence fault of the engineer, the terms provide for compensation to the engineer for that. And it further provides that if that suspension continues for more than 90 calendar days, then the parties need to reach agreement. So again, that opportunity for terms to be renegotiated, such as compensation schedule, etc., before the services are resumed, given the potential significant impact that a prolonged delay of that nature could have. With respect to termination, both the client and the engineer can terminate immediately where either one becomes insolvent. Appreciate that the likelihood of that on the municipal client side is likely very low, but nevertheless, again, just representing that mutuality and approach of the agreement, those terms are mutual. The client is also given the right to terminate the agreement. Both the client and engineer can also terminate where there's a material breach. So if one party is in breach, they give notice to the other. If that is not cured within the stipulated time, then that party would have the right to terminate the agreement for cause. Those terms are mirrored for each other. And then the client is also given the ability, added ability to terminate for additional reasons, including for convenience in section 1.11.5. And again, the engineer's entitlement to compensation under each of these termination provisions is addressed expressly with entitlement to termination costs or certain termination costs where the agreement is not being terminated due to the engineer's fault. That takes me to my last slide, which is just highlighting a few other terms of note in the agreement. In section 1.8, we have mutual confidentiality obligations provided for in the agreement. Relatively simple mutual confidentiality. And then finally, we have a dispute resolution provisions where, again, some of the changes that we provided for here is that neither mediation nor arbitration are mandatory. So there are steps that either party needs to take to either opt in or opt out of these processes in order for them to be required by the contract. So in the case of mediation, either party can opt out of mediation. The default is you will mediate unless one of the parties says, no, I'm not interested, with the understanding being mediation is not really going to be effective if one of the parties doesn't want to be there. But it is encouraged. So we have the default as you will mediate unless someone says no. Arbitration, on the other hand, is not mandatory unless one of the parties positively refers that dispute to arbitration. And finally, again, just trying to bring this agreement current in line with the Construction Act prompt payment adjudication changes that have come into force since the time of the older form that is being replaced. We also have a term that just acknowledges that nothing in these provisions derogate from either party's ability to make use of adjudication under the Construction Act. And so I appreciate there was a lot of information there, and I do see that there's questions that came in, and I'll be passing the floor over now to Sabina to talk to the insurance provisions of the agreement. But following that, we will get into our Q&A, and I will take this opportunity to run through the questions so we can jump right into that momentarily.
Thank you, Nick. That was really good. And speaking about arbitration and mediation, insurers definitely prefer that because what we're seeing now is since COVID, courts are very behind. Average claims are taking 7 years to settle. It's just a long, drawn-out process for keeping claims on the books. Anyways, I wanted to be part of this committee because we handle small and large engineering, do professional liability for small and large engineering companies in our office. And we see a lot of contracts come and RFPs come across our desk, and we're forever needing to make amendments or changes to them so that our clients can comply. So I wanted to talk about some of the issues we're seeing in those agreements. So I took the professional liability, I took the insurance piece out of the contract, and really it's similar to what it was before, but what we updated it to include cyber liability, because we're seeing more and more hits now, and firms are really having to address this. It does put you behind, and having cyber coverage is like a blanket around you with hand-holding on what you need to do, how you need to do it, and with experts coming in and assisting you if you don't have the expertise in-house. So, and markets have been very tight in the last few years, like during COVID, prices of going up, but things were going crazy, but we're seeing competition now and prices are coming down. So even for smaller firms, cyber is becoming affordable, and you should look into it and consider it. But what I really wanted to talk about is what we put on the service guideline. And if you can flip to the next slide, that'd be great. So as mentioned before, we're seeing RFPs come across our desk, and a lot of the local engineers carry 1 and 2 million limits. That's standard. And if you canvass the insurance companies who specialize in this, 99% of claims fall under 300,000 or 3 million in settlements, under 2 million actually in settlements. It's only a handful that they see, and including very large multinational companies, it's only a handful of issues that ever fall over $2 million. Very rare. A lot of it is just small, fix this, it's a crack there, it's a burst pipe, it's a lot of small accumulative items that come up. And I need to qualify this because I'm talking about projects that would be under this agreement, an MEA agreement, and I'm not referring to any large design build projects, Infrastructure Ontario projects, Metrolinx projects, nothing of that level or size. That's not what I'm referring to. I'm referring to projects that local engineers would be considering that municipalities would hand out. Okay, so things I'm seeing coming across the desk, a water plan study, and they need a 5 million limit. And you have to understand the smaller firms carry a 1 or 2 million limit. And if they're being asked to provide increased limits of 1, 2, 3 million limits to up their coverage to 5 million on professional liability, they're going to be charged $2,000 to $2,500, doesn't matter how small the project is, as a minimum premium per million to increase their limits. So it can cost an engineer to go from a 2 million limit to a 5 million limit, $7,500. And if they're being paid 10,000 on a study, it just eats the entire profit away. Now that's a very small scale, but when we take it on a bigger level, for larger projects, we're seeing quotes $70,000, $80,000 come in for these increased limits, when the client only has a fee of $80,000 on the project. So the compensation to liability is just completely out of whack. And so I've sort of put in place here limits that can be incremental to geared a little more to the size of the project and the exposure. And then I had feedback from some municipalities saying, well, we get, and I understand that you get a lot of lawsuits from slip and falls, car accidents and things like that, claiming site safety. But truthfully, engineers are not responsible for site safety. That is not, they are not responsible means, methods on a job site. That is the contractor's responsibility. And in fact, if engineers take on the responsibility for that, the insurance won't cover it. There's actual exclusion for means, methods, and safety issues. So that's not their role. And that's really where a car accident, they're going to claim signage issues. That's what the contractor does. That shouldn't fall back on the engineer's shoulders. So I'm hoping this is a very good, equally balanced agreement. So I'm hoping both municipalities and engineers will be comfortable using it. We've made sure that it complies with insurance conditions. So you're in line with what's needed. And I would say to the municipalities, if instead of having excessive limits being required by their purchasing departments, that maybe they look at and assign liability a little more to what the exposure actually is on a specific project. And if anything, be much more careful on who you're hiring as a contractor, and not just go with the lowest bidder, because it's caused a lot of problems. So, I mean, that's all I'm going to say in a nutshell. And if you have any questions on insurance, I'd be happy to answer them. Over to Andrew.
Thank you, Sabina, and thanks to all of our panelists for your remarks today. Risha, I understand, as Nick mentioned, that we have a number of questions, so I'll turn things over to you.
Yeah, we do have quite a lot of questions.
If
The
I
first,
might actually, I thought a number of them could be consolidated together, if that's okay. I don't want to, but I did see that a number of them were kind of about similar or overlapping issues. If I thought I might just jump right in on those, if that's okay.
yeah, sure.
Yep.
Okay. So a few of the questions that came in were about statutory holdback, and with respect to that, the agreement does not get into the details of release of statutory holdback. It just makes payment subject to applicable requirements of the Construction Act. So while we have facilitated, like we've made the payment provisions, like, you know, if you have an issue with an invoice, you'll advise within 14 days, and an invoice is due and payable within 28 days. That's consistent with the Construction Act. With respect to holdback release, there are not terms specifically stipulating details in that regard. Another kind of set of questions that were coming up are about the engineer's IP and the intellectual property provisions. So, you know, one of the questions was about, so I guess first of all, if a contract is silent about what happens or who owns the rights in an engineer's work product, their deliverables, as we've defined in this agreement to be the designs, drawings, plans, specs, reports, etc., that the engineer prepares on behalf of the services. The engineer owns all rights to those documents by default, and in fact, the owner arguably, or client arguably, without anything in a contract, would have to infer and make an argument about what license they have been given for use of those by the nature of the agreement if it's not expressly set out. But the default is that the engineer's IP, their intellectual property, their copyright, their rights is owned by them. And so that is where this agreement identifies and distinguishes that intellectual property that the engineer holds and protects it. And then it provides, though, the client with a broad license for use of that for the project. And so I think those were a number of the questions asking about intellectual property and what would that apply to. So it would apply to any deliverables that the engineer produces in the course of performing the services. And so if the parties are looking for, different deliverables to be treated differently, that would need specific terms outside of the agreement or supplementary conditions, for example. So I think, Rishi, I can go through and I'll click off the ones that I think those two things answered, but I think that kind of consolidated a number of the questions that were coming in on the same point.
Yeah, thank you so much for that, Anik. We have a question for Matthew. Could you elaborate on how a municipality would apply this agreement? Some questions on the application. Is this to be used as a basis for terms of an RFP or RFQ, or is this agreement made after RFQ or RFP submissions are received? Section 3.1.6 and 3.1.7 require costs as a part of the agreement. So we presumably would need to have a service provider confirmed before this agreement is finalized.
Yeah, so good question. This is similar to, I would like to phrase as a construction contract. You have contract A, contract B. So your RFP, RFQ document is in contract A, where you outline your terms of your procurement practices. And then these terms and agreements are after that. So these will be signed after you select a successful consultant, you fill in the prices and you fill those appropriate sections in. So this would be your second part of your agreement as you produce or progress through the assignment with the successful consultant. So if you look at it that way, that's the way I would approach it. I would just add, you should put these terms in part of your RFP, RFQ document so the consultant bidding knows the terms that he's going to sign on to once he is successful. So they still should be there, but they'll be blank, but at least he knows the terms and agreement they'll be entering on.
Thank you, Matt. We have another question. How do you recommend setting up a project to give yourself the ability to not assign a project to a low bidder?
That would be based on an RFP practice. So RFQ, you're generally stuck with the lowest price wins. And I would approach an RFQ practice if you have clear defined scope of work and you know what you're going to do, and you can clear define the scope of work to the consultant you're retaining, then it could be low bid. But if you have some flexibility in the approach the consultant can take to the assignment, and you want to really highlight more quality and performance and experienced team, you can go the RFP route. I don't know if Matt Eads has something to add to that as well, but
Yeah, thanks, Matthew. Yeah, I would reiterate your evaluation criteria could come into play there. And obviously there is a ability to talk with procurement departments to kind of get that balance right, as they push very much on the qualifications and competency and value perspective of our services. But obviously clear scope kind of helps with all that. And ultimately we want to work on good teams, good projects, well defined, and makes things easier. But yeah, playing with the evaluation criteria can help that for sure.
Yeah, and just to be clear, like this agreement form doesn't prescribe any type of RFP process. It could be included with an RFP with what payment terms you're looking for your process set out, for example, but the document itself does not, it is not saying that this is how the contract needs to be incorporated into any RFP process that a municipality may conduct.
We have another question here. Can you explain a bit on penalties for engineers on termination and delays caused by the client, excluding force majeure?
Yes. So for example, um, where, sorry, I'm just going to the section. So for suspension in 1.11.1, for example, except to the extent that the suspension was required due to the engineer's negligence or breach, the engineer is entitled to payment for direct costs reasonably incurred as a result of the suspension, and then the schedule for their performance gets extended. The engineer has a positive obligation, though, to mitigate their costs. If we go to the provisions that are for cause, so if there is a material breach of the agreement, and I think I saw a question that asked, you know, what would a material breach be? Unfortunately, it's context specific, but just a walking away from the job altogether. I'm just going pens down and not doing anything further. Could be an example where there's no right of suspension or anything. That could be an example of a material breach. Or, you know, the corollary for the client might be, I've just not paid for 6 months, even though there's been payment due. So those are potential examples for material breach, but a material breach at law is really something that goes to the heart of the agreement, that goes to the key terms and obligations that the parties signed on for. So so a material breach would need to be something that really material significantly impacts those things. If there is termination in that section for cause or upon insolvency, the client pays the engineer for all services performed to date. And where that termination is by the engineer, because either the client was insolvent or they were the ones in material breach, the client also reimburses the engineer for direct costs reasonably incurred by the engineer as a direct result of the termination, but excluding consequential damages. And so what could that be? So let's say, for example, the engineer had a contract with a subconsultant that they now need to terminate. There could be costs associated with that, break fees, things like this. So that might be an example of a termination cost. But again, lost profits, these types of things are excluded from what the engineer could recover, since they are not entitled to consequential damages under that circumstance.
Uh, Thank you, Anik. We have one more question. I understand that obtaining the permits and approvals are the client's obligations, but the consulting engineers are hired to understand the requirements, complete the required technical work, and submit the applications and seek the permits. Wouldn't this then make it the consultant's responsibility to make the client aware of this obligation?
I'll take a stab at answering that. I think that's kind of a clear definition of, you know, who's responsible for what in terms of the services. Obviously, the consultants, they typically provide the information to submit the application, but most of the time the application is directed by the client and they potentially pay the fee. So again, I think you just utilise the service definition of who's responsible for what in terms of what criteria, just so absolutely clear and who's paying for what as well, because sometimes there's an obligation to submit the application on behalf of the client, but sometimes it's direct and some approval bodies want it direct. So again, you just need to clarify that position between the two parties, but clearly defining the elements of the service.
Yeah, kind of build up on Matt was saying. I think this pertained to maybe section 1.4 that Nick was talking about. It says the client's responsible to pay for all the permanent fees, unless specified otherwise in the agreement. So unless you know up front that you want what permits and fees need to do, the consultant needs to then put it in their bid and they can cover that fee off. But as long as you specify that up front, is here's a permit required and here's what you're going to include in your proposal. So make it fair. So in transparency is the biggest thing. Is the consultant needs to know what permits and fees he's covering for his proposal, or the city's or the client is on the hook to pay those otherwise. So as long as you're clear and upfront and make it fair for them to bid, so.
Absolutely.
We have another question. It goes, the use of the term engineer along with the definition seems to limit the use of this agreement for services under the scope of engineering practice. Any suggestions on how to use this agreement for services outside of the engineering practice? Being in a municipality, we use the same existing agreement for both scenarios as the client is referred to as consultant.
I think what I'll say is, the reason for that is very intentional in that this agreement was prepared specifically for use between municipalities and consulting engineers. And while there's certainly a lot of similarity, overlap, and it may be that the terms of this agreement would fit perfectly for you in a relationship with a different type of consultant, that is not the lens through which this agreement was prepared or the parties for whom it was intended to be used. So, for example, um, certainly my expectation would be if you gave this to an architect, they would instead ask that you perhaps consider something like the OAA 600, which is an agreement prepared specifically for use by architects, as opposed to an agreement that's been prepared by engineers and municipalities for their use. So I don't know if Matt, if you had anything you wanted to add.
Yeah, I would say that's the lens we look through. That's what we, it's in the name of the two entities.
Very specific because we see a lot of engineers being hired under contracts that are geared for contractors and not the consulting side, and it just doesn't work. The requirements are different. So this is specific for consulting services from engineers.
Another question is, why aren't engineers and contractors evaluation not part of the standard contracts?
I'm not truthfully quite sure what that means.
Yeah, we don't have any, if you're looking for like an evaluation or a performance evaluation, that's not part of this. This is to set out the terms of the agreement during the assignment itself and how parties negotiate as they proceed through that assignment. If your municipality wants to develop your own performance evaluation for consultants for your own internal use, that's kind of yours, but we're not recommending that this time. These are just kind of outlining the terms of an agreement between the municipality and the consultant, not really performance management.
Thank you, Matthew. We have another question. Any thoughts for these new updates with regards to existing contracts with consultants? Which one of these updates would you recommend investigating further for possible incorporation through an amendment?
I can maybe ask Anik to build on it, but I would not recommend changing your agreement halfway through an assignment.
Yep.
My lawyer brain says don't do it. Just you're stuck up front. But I'll ask Anik to maybe build off that from the legal's perspective.
Yeah, I mean, certainly if you're reviewing this agreement and you're thinking, oh my gosh, there's something here that we really need on this project, then you may, want to go back and see if you have opportunity to modify your existing contract. But if you go and try to renegotiate terms of your contract, you reopen the entire thing. And so, for example, if you've locked in a lump sum price on that contract, but now you come back and say, I want to add intellectual property terms similar to the ones that are in this contract, you are arguably opening up every term of your agreement for renegotiation. So, again, would recommend that if there's something you think might be missing, or that your existing agreements would benefit from, to consider with your legal counsel how you might approach that under the specific circumstances, because also an amendment to a contract requires consideration, i.e. both parties need to get something out of it. So it can't be a unilateral amendment, which again is part of why making changes could reopen terms like schedule, compensation, things like that are probably best left alone.
Thank you, Anik. Another question for Matt is, Is the hope that using this agreement provides a greater interest for consulting engineers in projects, knowing that this agreement is used with its protections for consulting engineers? Could a client expect to get more competitive pricing using this agreement?
I would hope so. I think this really opens up, MEA and ACEC both agree that this is a fair, balanced agreement, so the terms are fair. The risk is shared between both parties, as it should be. So it's really a fair, balanced agreement that maybe more consultant engineers can bid the assignment knowing the term they're agreeing upon. The more specialized terms you have in your RFP, depending if you're pushing more risk on the consultant engineers, they will bid that appropriately with a higher value. So I know MEA who speaks this is a fair, balanced agreement, so I hope ACEC shares the sentiment and
Yeah,
you
no,
get more competitive pricing. So
absolutely, Matt. Yeah, I'd kind of reiterate it's been a collaboration and an effort together to get these balanced terms, and ultimately we're looking at providing valued services and clearly defined services and having the conversation. But obviously the influence is also on the RFP side of things. We thought there's an opportunity to incorporate this, and we know we're bidding against standard industry terms that are balanced. It's definitely encouraging greater competition, and but obviously we understand what risk we're taking on as well. So again, from an insurance perspective, it's clearly understood. So yeah, strongly encourage the use of the agreement. But obviously, you know, like everything, the final terms are a collaboration and a conversation about making sure it's clearly defined between the parties.
Thank you, Matt. Since we are towards the end of the webinar, we'll take a couple of more questions. Does the agreement speak to the obligation of the engineer to perform the work with a sustainability or a climate lens?
No. Matthew.
yeah, you took the words out of my mouth.
Yeah.
The quick answer is no. Again, that could be maybe something you work with your council or your senior leadership. Is that a direction your municipality has undertaken and does? So that would be a subsequent term in your agreement that you put forward in your upfront terms there.
If I might, there were
Yes.
two other questions I thought I might quickly answer. Sorry, Rishi. One of them was speaking about section or clause 1.10.3 about what happens if the start of the project is delayed for 60 days, and it provides that then the engineer will have the right to renegotiate the agreement. And they ask about, well, what if that delay was caused by the engineer? How is that fair? And I think I just point out that the terms of this clause are talking about that being delayed in a way that not only materially affects the services, but also for reasons beyond the control of the engineer. So that clause would not apply if that delay was caused by the engineer, because that would be within the engineer's control. So the intent of that clause is not to allow the engineer to delay the start of the project for 60 days or more and then get to renegotiate their deal. The other one was a question about how does this agreement compare with CCDC agreements or documents? And I think, you know, certainly the CCDC 31, which is CCDC's standard form of consultant agreement, was something that was considered in as we considered the balance in this document, and something that was talked about and referred to as part of the conversations. And so we have a lot of correlations, for example, like definitions like value added taxes and things like that, that are consistent with the approach taken in the CCDC. The approach to the indemnities and limitations of liability is also similar, I will say, to approach taken in CCDC contracts. But, you know, is this you know, just a different version of the CCDC 31? No, this document very much is the product of ACEC-Ontario and MEA's conversations and their very specific looking to balance the municipal and consulting engineers relationship in a way that doesn't already have a market presence through a document like the 31, for example. I don't know if Matthew, Matt, you guys wanted to speak to that item.
Yeah, I mean, I think it was just another useful tool for municipalities to leverage. Again, we recognise there is a wider industry portfolio of contracts that are out there. Again, trying to learn from each other and learn from that best practice. As you say, this contract will also evolve, as we mentioned. As things kind of evolve in the industry, we'll look to be as closely aligned as we possibly can be. So, but it was through obviously that collaboration lens.
Oh, and one last thing, the Construction Act. I see one of the questions is, does it apply? Does it not apply? And I think part of the reason we didn't get into, specifying holdback release and things like that is that while we would expect the Construction Act to apply in most instances, design services, these types of things. Not all consulting engineer services reports, for example, are necessarily subject to the Act. And so that would need to be determined on a case-by-case basis. This has been made so that it works when the Act does apply, but it is not prescriptive. If the Act does not apply, you can still use this agreement. It will still work as well, but you would need to determine on a case-by-case basis whether or not you do have rights under the Act, like adjudication, like the obligation to take hold back and then release it in accordance with the Act.
I think that brings us to the end of the questions and answers. Over to you, Henry.
Thanks, Rish, and thanks for running point on questions. And thank you to our panel, Nick, Matthew, Matt, and Sabina for sharing your perspectives and your dedication to this collaborative initiative. We hope everyone here finds value in using the updated MEA ACEC-Ontario Standard Agreement in your upcoming projects. You can find the updated agreement on both associations' websites. And you will also find a recording of this webinar on both sites starting next week. So thanks again, everyone, for attending, and have a great afternoon. Thank you.